Hi, everybody. Usually a forensic accountant here. This is part 4 of the greatest pro se victory in the last 50 years. The reason that it is referred to that, and again, you should really take a look at 1, 2, and 3, but these are some of the courts that the case went through. I'm not going to read them all off, but you can see it went through almost every type of court you could go to, and probably going to the Supreme Court, not there yet. And just to bring you up to speed, I'm going to go over when the cases moved up to Harvard, they appointed a new judge. And obviously in New Jersey, we were winning left and right. We had some losses, but basically we were beating Harvard. This is over $800 million lawsuit. We had, I think, $13 million in fees. And even though we didn't have an attorney, we were pro se for a variety of reasons. But let's just take a look at the judge's credentials to remind you. This is a press release from the District Court of Massachusetts. It was released in March 2021. It basically says the judge is a Harvard College and Harvard Law School graduate. Only one in the District of Boston with those credentials. And somehow he got picked. I wonder how that happened. He lectured at Harvard Law School, active alumnus of Harvard College. Judge Young has served in various capacities. So he's always there serving in some kind of capacity. He's on the Board of Overseers and Alumni Association. Now, what's interesting about this is the Board of Overseers is basically your manager at Harvard, okay? You control the policies, you're dealing with them, you're supposed to protect Harvard, and yet this was never disclosed to us. We're naive pro se litigants. I'm thinking, okay, it's a federal judge, you know, I don't have to go back and make sure he's fair and unbiased. Never disclosed at all. Everybody else knew it. Harvard knew it. Harvard's Ivy League lawyers knew it. You know, I'm sitting in court thinking that it's going to be fair. So anyway, it was not fair. And I'm going to go into why. You know what we did? You know, obviously and again, this is really in 1 and 2. We passed all the courses. We did receive some certifications, but not the one we were looking for. And I'm going to go through why, mainly because, you know, they had a judge that was, in part of Harvard's management. And again, this is a little bit of a review, but this is in the pleadings they filed, Harvard's attorneys. They filed documents that we never saw. They were false, fake documents, which you can't do in the. This was in this motion. It's not a summary motion because there's no discovery, but they based it on this case called Angelos versus Toca Pharma, that they could file these documents. And if you look at the actual case, it's pretty clear that if you question the authenticity and its challenge, you can't rely on these documents to dismiss in the motion, which they were doing a 12B6 motion. You can't dismiss. And I told the judge this. But anyway, this is background. Go look at 3 if you really want to get into it more. On a side note, this is the courthouse, which I really enjoyed going there. The courtrooms are great. First Circuit's there too, so it's, you know, the district court and the First Circuit are kind of like, you know, buddy, you know, golfing and on their boat. So you're not going to get a different, you're going to get a judge protecting the lower court rulings in most cases, especially when you're pro se. But I enjoyed going to here. I'd recommend going. I just really a lot of fun going there and traveling up from New Jersey. Of course, it was not fun. You know, what happened in the hearing, which is going to be in another video. So after they filed those false pleadings, I wanted a SIR reply, file a SIR reply, and the judge never responded. And again, I didn't understand why. The day, I think 2 days before my SIR reply was due, he said he granted it. So this is a total joke. And then he set up a hearing, and I said, okay, great. I'll go up to Boston. The judge is going to be fair. I'll explain to him. I just want discovery in a jury trial. You know, that's all I want. I'm not expecting, you know, listen, this case started in 2016. There's 6 years of litigation. And you know what? I didn't win all the battles. I won the majority until we got to Massachusetts. But, you know, so he set up a hearing. And at the hearing, the judge basically turned this 12B6 motion to a summary judgment, which means is, again, I showed you the case law, which says that Harvard can't submit the documents they submitted, especially if I say they're fraudulent. Okay, which I told the judge, and the hearing's going to be in another video. He turned it into a summary. Summary judgments for when you have discovery, you know, and you have deposition. There's no discovery here. The judge had a job to stop me from going to court because it's an $800 million lawsuit against Harvard. And he did. I mean, he was very successful here. So here's a copy of the notice to dismiss my case. Okay, it just says order of dismissal. Okay, he dismissed the case. Now remember, I filed a 300 page amended complaint. No, they didn't look at the complaint. He's dismissing this based on what? Based on documentation submitted by Harvard that was fake, fraudulent, and made up. We had no discovery in the case. He does an order of dismissal. So, I'm sorry. So what we did was I filed a complaint with the district court for judicial misconduct and disability. And what's supposed to happen here is, you know, the Chief Justice down, you're supposed to look at the you know, say, hey, was Judge Young fair and independent? That was my claim. He wasn't. He didn't disclose it. You know, basically an employee of Harvard. You know, how did he ever get selected for this case? So of course, you know, again, they're all in the building. He says, no, everything's fine. The judge can do that. You know, he doesn't have to disclose. That's okay. So I said, okay, well, it's still being appealed. We're appealing this ruling here. We're going to lose that one too, but. Then I went into the First Circuit Court of Appeals, and I said, "Listen, this judge made this ruling. He turned, you know, a 12b6 ruling into a summary judgment. He's not a fair and all this stuff was in there. Let me just show you my application. Okay, so this is the United States Court of Appeals for the. Oh, this is the Third Circuit. No, anyway." Where's the first? But there was one for the First Circuit too. So I was in as a pro se litigant, going to two circuits appeals was pretty impressive. So we were in the First and Third Circuit. This is the Third Circuit, but I got a similar notice from the First Circuit. And what I told them, I said, listen, you can't turn you know, a 12b6 ruling into a summary judgment. And of course, remember, I showed you a picture. They're all together. They dismissed the case. They're saying no. You know, judge can do that. So what's really, really interesting here is that because lawyers love case law, okay, this case law is going to shake up the legal community because in this case, which is all documented, here's some important case law that was established. One, federal judges can dismiss cases based on fraudulent information submitted by defendants they have relationships with. This is proven. Federal judges can turn a 12b6 motion into a summary judgment based on new fake evidence submitted by defendants without any discovery. Federal judges can have close relationships and management positions with the defendant and not disclose those to pro se litigants. Federal judges can hold pro se litigants to higher legal standings and pleadings than Ivy League educated attorneys. Every time, all my briefs and everything were held to outrageous standards, and we still won. Well, we were before fair judges, but obviously we lost here. Federal judges can ignore amended complaints. I filed an amended complaint. The judge never even looked at it. He didn't even mention it in his dismissal. And I appealed that, and I told the, you know, I told every court that he didn't look at our amended complaint. I mean, what is that about? Federal judges can harass pro se litigants, delay pro se use of the case management filing system. Federal judges can ignore pro se litigants during a hearing if they dislike their pleadings, which he did. Federal judges can say that they carefully read the complaint even when they did not. And again, all this stuff is going to be proven in a certified transcript of the hearing, it's absolutely hilarious. Everybody thought it was hilarious. But anyway, hopefully you guys liked this video. If you did, smash the like button, leave comments. I'll get back to you. One of my staff will. Thanks a lot.